via the live stream. We have had so many remarkable tech issues this morning, but we are beating them back right now. So thank you for persevering. Joining us today is William Most. He is a constitutional rights lawyer based in New Orleans, and he leads the firm of Most and Associates, which I think is the best name ever. He specializes in issues including free speech, false imprisonment, employment, wage theft, and criminal defense. I'm sorry, I'm getting so many notifications of all the things that they're telling me is going wrong with this. Oh, goodness gracious, where did Chris go? I don't even know what to say. I don't even know what to say. Chris, you back?
I'm back.
Okay. Praise God. All right. We're going to keep going. I will continue introducing William. He specializes in issues including free speech, false imprisonment, employment and wage theft, and criminal defense. He's going to be talking to us today about a suit that
hopefully,
yeah, hopefully, if we get there, he's bringing against Secretary of State of Louisiana, Nancy Landry, for a constitutional amendment that will be on the ballot this March. Chris, it's telling me that your recording has failed. So I don't really know what to do.
Well, hold on.
I really don't know what to do.
Let's go back again.
Okay, Chris, just why don't you there?
Look, I'm here.
If it fails one more time, just don't come back, because we'll just do your audio only, because William has other things to do than persevere with us.
Okay.
All right. Well, after all those travails, let me read the scripture of the day. It is Ecclesiastes chapter 11, verse 6, and it says, "Sow your seed in the morning, and do not be idle in the evening, for you do not know whether morning or evening sowing will succeed, or whether both of them alike will be good." And as I was reading that this morning, I don't know that I've ever spent that much time on this passage before, but I thought it must be the original source of Apostle Paul's admonition in the book of Galatians to not grow weary in well-doing. It's a great encouragement to us to be diligent in the work the Lord has called us to do, because just as a farmer doesn't know which plantings will succeed, we don't know what projects will succeed. And since I'm with attorneys here this morning, we don't know which cases will succeed. We don't know which lives will be changed for the better by our efforts. And we don't know who is one kind word away from turning to the Lord. But we do know this: if we don't put forth the effort, if we don't try, it won't happen because of us, and it may not happen at all. So be diligent in your purpose today, and don't allow yourself to give up. This is a word to us too, because the work the Lord has called you to do matters. Chris, you're back with us.
I'm back with you, and I think, Danielle, we're living proof of the scripture this morning. Can anybody hear me?
Yeah, we can hear you. Don't worry about coming back in on the video, Chris, because we just apparently it does not want to do so. But we've got you over the phone. So continue.
And we will prevail. I was going to say we are living proof of working through it this morning, because we've never, ever had this kind of technology. There's some nefarious force out there that perhaps does not want William's truth to be heard today, but we will never surrender, and we are here. Thank you for the scripture, Danielle, this morning. And kindness is critically important, and we can fight hard, and we can fight diligently and still be kind to each other. And that's very, very important to remember. William Most, as you said, had a lawsuit now representing two pastors, two teachers and a pastor, and he's challenging Amendment 2, which would amend parts of Article 7 of the Louisiana Constitution set on the March 29th ballot. This is a hugely important lawsuit. I've read the suit, and it is very well drafted, very well written, and very compelling. William, I want to start with a question at the outset. The governor sold this constitutional amendment in part, if not in substantial part, by trying to persuade Louisiana citizens that this would etch in constitutional stone a permanent teacher pay raise. Your lawsuit disputes that and argues that a permanent teacher pay raise is absolutely not guaranteed under this proposed amendment. Explain.
Yeah, thanks, Chris, for having me on the show and talking about this. And that's exactly right. So we are currently challenging a ballot proposal that's going to be on the March 29th ballot. And what it is that there are more than 100 pages of proposed rewrites to the state constitution. And those have been condensed into a one-sentence ballot measure. So what voters will vote on March 29th for Amendment 2 is one sentence. But if passed, it would make more than 100 pages of changes to the state constitution. And one of the things in that one sentence is a statement that there will be a permanent teacher pay raise. But that's not true once you get into the fine print. Once you dig into it and see how it actually works, you see that that's not true at all. Some teachers will likely get a continuation of the same pay they've been getting. Other teachers will get a pay cut. But as far as we can tell, no teachers will actually get paid more because of Amendment 2, which makes the ballot measure fundamentally misleading and is one of our legal arguments for why it shouldn't take effect.
And William, would you maybe outline for us what the Louisiana state law says about what needs to be included in a constitutional amendment? Because I think that's a critical piece of what we're talking about here. It's because your suit is saying that what the amendment declares or puts forward for people for the decision is not what's actually in the bill.
Yeah, that's right. So I think it's helpful to zoom out and look at the context. And of course, I'm sure all your viewers know that there's a federal constitution, the U.S. Constitution, and similarly, the state of Louisiana has its own foundational core document, which is the state constitution, which has been revised many times over the years. Our current state constitution was created through a multi-year process in the 1970s that led to the 1974 Constitution. And it does have a provision within it that allows the Constitution to be amended, right? These are documents that can change over time, adapt to changing situations. But if you are going to change the state constitution, you have to make sure you're complying with the rules. And the state constitution itself has some basic rules that ensure transparency and fairness. One of those is that if you're going to submit to the voters a proposed constitutional change, it has to have one object, right? One thing that the proposed amendments would change. And what we've got in Amendment 2 is they have tried to stuff maybe 40, maybe 50, maybe 60 different things, depending on how you count, into one thing for the voters to vote on. And that is absolutely not the way it's supposed to be. Because, and I'll read you a quote from a 1941 Louisiana Supreme Court case that I think really captures why voters need to have an up or down vote on each change to the Constitution. The Louisiana Supreme Court said that this rule prevents burdening a meritorious proposition with a vicious one, and alike prevents a vicious proposition from having the support of a meritorious one, and gives to the voter the right to have each separate proposition submitted to him in order that he may express his will for or against each separately, without being compelled to accept a provision to which he is opposed in order to have adopted a provision which meets his favor. That's the basic idea. When you submit something to the voters to change the Constitution, you do it one change at a time.
Yes.
But Amendment 2 tries to do 40 or 50 at a time.
Yeah. Great, William. That's such a great point. And to use this proposed amendment itself to illustrate your point, let's say, just assuming hypothetical, but it's not the case, but assuming this amendment would etch in constitutional stone a permanent teacher pay raise. In order to vote for the amendment and get that permanent teacher pay raise, you have to vote for an amendment that also, in the same amendment, narrows the tax property exemptions for charitable organizations. So in voting for the permanent teacher pay raise, you're voting also voting for something that would create more tax burden on nonprofits. That also, in your view, is misrepresented in the ballot language, correct?
Yeah, that's exactly right. So Amendment 2, these 100+ pages of changes include a really wide range of things, right? Everything from narrowing constitutional protections for church property, limiting local control over sales taxes, liquidating education trust funds, deleting a fund that supports infant mortality programs, changing the rules for taxing salty water, changes to gendered pronouns, deleting the constitutional authorization for farmers and fishermen's programs. So there's tons of different things in this. And it completely violates that one object rule. And so, yes, some people might want the teacher pay raise. This amendment doesn't do it. But even if it did, they would have to take all these other things that they might not want. And the fundamental problem is that's not being communicated to voters. That is being withheld from voters, and the truth isn't being told to the people of Louisiana.
Yeah. And William, it's my perspective that no bill brought before the legislature should be more than 3 pages. Because if they are expected to read this and confer with their constituents about how the people that they represent would like them to vote on this, it needs to be simple. It needs to be straightforward. And there needs to be one point that you're voting on. I mean, confusing all of these issues, how do you even weigh all of that? And, the truth is that we have seen this before in the legislature, right? In 2023, we had a budget proposal that was pushed by then Governor Edwards and brought by Republicans to ram down the throats of the Louisiana people, a huge change in the way that the budget was going to be dealt with. And they took on, instead of using the funds in a very conservative way that would pay down debt, they did other things with it. The point is, it doesn't really matter. The bill was very, very long, and legislators had a very short time period to review it. It was like 2 or 3 hours before the end of session. And this is the same thing that happened with this bill. It came at the 11th hour at the end of a 2-week special session on taxes. And it is, I think, there are a number of legislators who probably felt like they were taking this on good faith, that people in their own party, for instance, were bringing a bill that that was going to be something that actually did simplify the tax structure, like Governor Landry campaigned on. However, it seems like, to me, I'm speaking for myself, the tax structure has gotten more complex, and they're addressing things in a very ramshackle sort of way. I want to touch on one issue in particular. One thing the amendment proposes, and you spoke about it as in your list of things that it does, is that the amendment proposes to disempower localities to determine their own tax structure, and it requires them to be uniform with the state. And I mean, where does the state get the authority to tell localities what their tax structures are? It seems way out of line with the basic principles of federalism, but that's buried somewhere way deep within this 118-page amendment.
Yeah, I think that's exactly right. And I think if you asked legislators who voted on this if they understood what was in it, I doubt many of them knew even a substantial portion of what was in it, whether it's limiting local control over sales taxes, or how many of the legislators who voted for this knew that they were potentially narrowing constitutional protections for church property, right? I don't know that they knew that. Or allowing for higher taxes on takeout food, right? There are so many things buried into this that you don't even find, unless you dig into the fine print, that I'm not sure the legislators understood what they were voting on, much less, asking voters to vote a one sentence up or down that incorporates more than 100 pages of changes. Yeah, so I think there's failures of transparency at all levels here.
And one other thing, William, that Chris and I were talking about before the show this morning is that this is not like you say it's 118 pages, right? It's not narrative pages like reading a book. These are all pointing at different pieces of the tax structure that you have to then refer to other documents to understand. This isn't some kind of straightforward 118 pages even. This is something that would take probably a good week, 2 weeks to comb through to fully understand. I mean, you know how long it took you to comb through it to understand. Maybe you can give us an idea of the amount of time it would take for an attorney to comb through this.
Yeah, that's exactly right. I mean, we had a team of lawyers who were working on just trying to categorize all the things that this would change or delete or destroy in the state constitution. And it took a team of us quite a long time to do that. And I think, for context, the process of building this state constitution, as I mentioned, took, several years in the 70s. And it involved people from all walks of life being part of the convention. There were hearings before they even began the deliberations at the Constitutional Convention. They had hearings around the state to get input from members of the public. And then there was this long process where these provisions were carefully crafted, put together. These were the founding fathers, right, in the 1970s of our state constitution. And then to have all that, much of it destroyed in a 2-week session with very little transparency, without maybe even the legislators understanding what they were being asked to vote on, and then rushing it to voters with a misleading ballot language, I think is a real problem to take an axe to something that was built so carefully.
Yeah. Chris, are you still with us?
Yeah. And to your point, William, there were 100, and as you pointed out in your lawsuit, there were a total of 135 delegates to the 1973 or 74 Constitutional Convention, 105 of whom were directly elected by the people. So the people had a powerful voice in the ratification of that Constitution. And I don't believe that is the case here. But I want to drill down for a minute here, William, on this exemption for religious organizations. The ballot language says that it is retaining the exemption for religious organizations. What the ballot language does not say is that it is changing the Constitution, whereby now the nonprofit or the quote unquote religious organization has to be 100% explicitly devoted to religious operations. Whereas now under the Constitution, any charitable organization that is a nonprofit would get the property tax exemption, even if it's not explicitly religious. The ballot language does not say that it's actually going to cause a lot more charitable nonprofits to have to pay a lot of property taxes.
Yeah, and I think the wording is ambiguous, right? And I think that what you described is one possible reading, but no matter how you read it, it's a narrowing of the current protection. So backing up a little bit, our state constitution protects from taxation the property of nonprofits that operate as religious organizations, right? Churches, other groups. Their property can't be subject to property tax. That's a constitutional protection. The Amendment 2 would delete that and replace it with something much narrower. You're right. It says operated exclusively for religious purposes as a house of worship, residential housing for clergy, priests, or none, or a seminary or other similar use. And so I read that as actually looking piece of property by piece of property, how that property is used, right? And requiring that it be used only for religious purposes to qualify for constitutional protection from taxation. So let me make that more concrete. The way I read this is, if you're a church that has a chapel and a fellowship hall, right? The chapel, if it's used exclusively for religious purposes, would keep its tax exemption protection. But a fellowship hall that's maybe used for religious purposes and also some secular community events, maybe a feed the homeless kind of event, that could potentially lose its constitutional protection from taxation. And so I think that there's going to be potentially scrutiny property by property, and much of the property owned by churches could lose its constitutional protection if Amendment 2 is passed.
That is so insane to me. What kind of effect do you think this is going to have on the general landscape for charitable organizations in our state? I think about organizations that rescue people from human trafficking. I think about educational organizations. You think about people feeding the homeless. What does this mean for these kinds of organizations? As someone who, as a taxpayer who donates money to a charitable organization because I believe in its mission, I'm going to now have to expect that that money is going to a greater level of overhead than it would be otherwise if these organizations are now being forced to pay property taxes.
Yeah, no, it's a very good question. And, to be clear, this wouldn't immediately require some organizations to change what taxes they pay, because what was the constitutional protection, if Amendment 2 is passed, will be moved to a statute. So nothing will change on day one if Amendment 2 is passed. But that property could lose its constitutional protection, right? Which means that in the future, a legislature or governor who finds that nonprofit or that church to be out of favor or speaking contrary to what the government wishes could, potentially be subject to taxation. So our constitutional protections are placed in the Constitution so that, changes in administration or changes in the legislature don't make you worry that you could be targeted for abuse. And when we take things out of the Constitution, we create the risk of problems in the future.
And it raises an interesting point, because I don't believe it's the state that sanctions a nonprofit, right? It's a federal. You apply to the federal government through the IRS for nonprofit status. So then it's the state splitting hairs once that status is granted.
Yeah. So, this is complicated. And I think anyone who's a member of a church, who runs a church, or if you're just a member of one, may want to talk to your church leaders about this, right? Because I don't know how many people know about this. Same with, anyone who's a teacher or part of a group of teachers. I don't know how many of them know that they are not likely to get the raise that the language suggests they would. These things are fundamentally misleading. And so we're not saying that every change proposed in Amendment 2 is bad. Some of them I think are probably good ideas. But what we can't do is batch dozens and dozens of changes together, make voters vote all of them together up or down without telling them what they're going to get.
Yeah. The ballot language says the constitutional amendment will provide a permanent teacher salary increase by requiring a surplus payment to teacher retirement debt. That's not entirely true, is it?
No, it's not. So, and you have to get into the weeds, get into the fine print to see how this works. So my understanding of the way this works is that's what the ballot language says, right? Teachers will get a permanent teacher salary increase. But then once you get into the text of this Amendment 2, and then you get into the companion legislation that implements it, you see that is not how it's going to work. What's going to happen is, for the last couple of years, teachers have been getting a $2,000 per year extra stipend. And what Amendment 2 would do is take a constitutionally protected education fund, liquidate it entirely, put it into the teacher retirement system, and then tell schools they don't have to pay as much into the teacher retirement system because all this liquidated money is coming in. And then schools are supposed to use the savings from what they're not paying into the teacher retirement system to then backfill that $2,000 stipend that teachers have already been getting. So if everything works according to sort of, best case scenario, teachers would continue to get the extra $2,000 they've been getting, which is not a pay raise, right? A pay raise means you get more. This would mean you just get the same. But then there's also language that says, any school where your savings by not paying into teacher retirement system don't equal the $2,000, you don't have to pay the $2,000. So those teachers would get a pay cut. And then there's a bunch of schools that don't participate in the teacher retirement system at all, like many charter schools. And as far as I can tell, those teachers will just get cut out entirely. So in no way is it true, as far as I can tell, that Amendment 2 would lead to a permanent teacher pay raise. At best, some people getting the same amount.
Right. William, it just seems disingenuous to use the language provide a permanent teacher salary increase when even under a best case scenario, they're just going to continue getting the $2,000 stipend. There is no increase. I mean, this language is just thoroughly disingenuous, the ballot language.
Yeah, and I think, look, if you as a voter are being lied to about what you're being asked to vote on, that should make you have some real questions about what is this process? Why am I being asked to vote on something that's not truthful? Because there's at least three things in this one sentence that's being proposed to the voters. We counted at least three things that are untruthful. First, the thing about retaining the religious protection. Second, thing about teacher pay raise. And then third, the ballot language says that it will, quote, modify operation of certain constitutional funds. But when you read the Amendment 2, you see that those funds are being deleted entirely. So if you took your car to a body shop and they said, okay, we'll modify your car, come back in a couple of days, and you came back and your car was completely destroyed, you would say, you were not telling me the truth when you were saying you were modifying my car. You destroyed it. Same thing here. Voters are not being told the truth about what would happen to their constitution.
Yeah. And Chris, I know we're in an awkward position with you having to join by phone, but I know you also wanted to maybe discuss the income tax piece of this.
Yes. The ballot language, again, and it's important for the benefit of our listeners to distinguish between the ballot language, which is what they're going to be reading when they go in to vote, and the 115-page bill from which this ballot amendment is purportedly derived. I'm reading right now from the actual ballot amendment. And it says that the amendment will include revisions to lower the maximum rate of income tax, increase tax deductions for citizens over 65. Okay, that right there. What is the problem with that? How is that inconsistent with the actual bill, William? And what does this do? What is the reality of how this will change or could change our tax burden?
Yeah, so I'm not so sure that those two things are misleading. I think those do reflect some of what's in Amendment 2. I think the problem there is that when you look at the one sentence that's being pitched to voters on the ballot on March 29th, it only mentions things like that, things that will appeal to voters, right? And it doesn't mention any of the things that may be less appealing to voters, like, limitations on local control of taxes or narrowing constitutional protections for church property. So the ballot language is what I phrase as all dessert, no vegetables, right? It only tells you the nice stuff. It doesn't tell you the stuff you might not like so much. And in that way, the ballot language violates the law. Louisiana law says that ballot language has to be, quote, simple, unbiased, concise, and easily understood, right? If you can put something to the voters, it has to be unbiased. But when you only tell them about the nice stuff and hide the not so nice stuff, you're not being unbiased at all.
Yeah.
Well, and William,
I have one last thing I want
Sure.
to
Go ahead,
mention. not, this is something that I wanted to bring up to you, William, that I didn't discuss with Danielle before, but I just thought about it. Is this an issue or not? There's a provision in the bill itself, which says our present Constitution authorizes federal income taxes paid as an allowable deductible in the computation of state income taxes for the same period. So we're now allowed to deduct the amount of federal taxes that we paid from our state income taxes. And it says the proposed constitutional amendment repeals the present Constitution. So does that mean that Louisiana citizens will no longer, at least as a matter of constitutional right, have the right to deduct from their state income taxes the amount of money that they paid on the federal level?
Yeah, so I'm looking at it now, and you're right. That provision, that constitutional protection, saying that what you pay to the feds can be a deduction on your state taxes. That's currently written into the state constitution. It's constitutionally protected. It does look like that's being deleted and not replaced in the Constitution if Amendment 2 is passed. Now, it may be that that's replicated in a statute somewhere, but that means then it's at the whim of any future legislature to tinker with, and you lose the constitutional protection.
Yes. In other words, it's easier to repeal a statute than it is to take something out of the Constitution, which is why, as you mentioned earlier, some of these very important things need to be codified in the Constitution. In other words, it offers greater protection for certain rights and privileges than something that is merely in statutory law. Is that what you're saying?
Yeah, that's exactly right. If something is in the Constitution, that means it's solid, it's dependable, it's very difficult to change, and rightfully so, right? Our core freedoms should not be subject to the changes of, who wins a state legislature seat, right? Certain things are important and need to be protected. And the wisdom of, previous generations was that these things should be in the state constitution. And to take them out without really telling the voters what they're taking out is a real problem.
And William, we started out the show, tech issues aside, and thank you so much for persevering with us. It's been a crazy situation with our tech issues. But if your suit wins, which your suit is against Secretary of State Nancy Landry as the administrator of the amendment language, I believe, what happens if you win, and what do you recommend people do if it does end up as is on the ballot on the 29th?
Yeah, so it's a good question. So we filed our lawsuit, and we are going to be seeking a preliminary injunction, asking the court to rule in advance of March 29th that the Amendment 2 should either be taken off the ballot, or if it's too late to take it off the ballot, that it shouldn't have any effect if it's passed. But even if that preliminary injunction fails, then the case continues. And Louisiana law does say you can retroactively invalidate an amendment if it failed to comply with the Constitution. So the fight will go on after March 29th, regardless of what happens with a preliminary injunction. But I think your question is exactly right, which is, what should voters do if they get to the ballot on March 29th and Amendment 2 is on there, right? I think in the lead up to the election, I would recommend that they ask questions of their community leaders, their friends, their families about what this means and how it could affect them. Talk to their legislators, ask if they understood what they were voting on. And then ultimately, it's my recommendation. I'll be voting no on Amendment 2 because I don't think it's truthful with the people. And I think that it is violating the state constitution in the way it asks them to vote, in one big lump sum, all sorts of completely unrelated changes to the Constitution. So I'll be voting no. And of course, it's up to everyone what they choose to do.
Yeah, absolutely. I'll be voting no as well, because it seems to be giving power to lies, to complete deception of the voters. And that just really gets under my skin and makes me quite angry at honestly, whoever put this forward as a single amendment.
Yeah. And William, this is, I agree 100%, Danielle. I believe, as you do, William, that when it comes to codifying, to amending the Constitution, something that fundamental, something that has such profound implications, the process has to be much more deliberative, much more reflective, and much more thoughtful. And I don't believe that any of that was the case here. I read the lawsuit, as I said at the outset of the show. I think it's very well written, and I think it's quite compelling. And I think it's a very, very important suit. And we just appreciate your taking the time to join us today and talking about these very important issues.
Happy to do it. Thanks for the opportunity to talk about it.
Great. Thank you, William. We hope to have you back maybe after you go to court and hear how things shook out, and we'll see how things advance on this. But I hope that we can move forward in a constitutionally consistent manner that really reflects the will of the people.
Agreed.
God bless you, man. Have a good afternoon.
Oh my
you.
goodness.